Welcome everyone to the session themed The Virtual Courtroom, Will It Enable Justice to Prevail? I'm Wayne Pisani, a lawyer by profession and leading the regulatory and compliance practice at Thornton. And today I'm joined for this panel to address this interesting theme by Chief Justice Emeritus Dr. Vincent De Gaetano, who's a former Chief Justice in Malta, used to be a Deputy AG as well as a judge in Strasbourg on the European Court for Human Rights. Dr. Luis De Gabriele, President of the Chamber of Advocates as well as partner at Camilleri Preziosi. Dr. Ian Staffrach, partner at Saliba Staffrach Legal, as well as Dr. Vanessa Grech, who is an Assistant Director at the Court Services Agency. As part of the safeguards and contingency planning resulting from the fight against the spread of the coronavirus, on 13th March 2020, Legal Notice 61 of 2020 was published, namely entitled Epidemics and Infectious Diseases, Suspension of Legal and Judicial Times Order for 2020, leading to the justice system to hit the pause button. On the other hand, 85% of business respondents to the survey conducted by Thornton over the course of June have indicated that they were able to continue operating virtually or within minimum presence, and 88% indicated that they will encourage customers to continue using their online services. Looking at this, and if I may address the question to Mr. Justice De Gaetano, was the right to an effective justice system impacted by the pandemic and the measures put in place?
Thank you, Dr. Pisani. There is no doubt that it was impacted. The extent to which there was an impact can be gauged, however, either positively or negatively. Undoubtedly, a number of people have had their cases put on hold. That is undeniable. And in fact, we have also had one constitutional court judgment delivered in respect of those people who are undergoing committal proceedings, which found that one particular provision of the legal notices in force was in fact amounted to a violation of the right to a fair hearing. The greatest impact, in my view, negative impact, was in fact the fact that many of these cases had to be put on hold, not only criminal cases, but also civil cases. And this, from what I gather, has been a problem, or in particular, with those members of the judiciary, with magistrates in particular, whose cases, district sittings and so on, kept piling up. On the other hand, from the positive point of view, of course, like everything in life, necessity is the mother of invention. So in both in various areas, not only in court, but also, let's say, at schools and in university, people had to resort to virtual meetings, virtual communication, using platforms like this, like Team and Zoom and so on. So, and this also shows that when it is necessary to make some innovations, if you are with your back to the wall, technology can step in to help quite a lot. Now, of course, this is not to say that virtual court hearings are the panacea, the solution to everything. There's no such thing, I believe, in the court system in Malta, at least, which indicates that one size fits all. Why? Because we've got different courts, different levels of jurisdiction, different workloads in different courts, and so on and so forth. So I would imagine that the pandemic has had two things a negative effect, yes, in respect of people whose cases have been put on hold. And this means that whether it's a civil case or a criminal case, it will take longer for that case to be decided. Will it be taken into account for the purposes of reasonable time under Article 6 of the European Convention? I don't know. I'm not quite sure how the court in Strasbourg, for instance, will be dealing with the situation. That's the negative aspect. The positive aspect is that I think this pandemic has spurred us on to try and use information technology and virtual hearings and so on, these platforms that we're using right now, to try and I wouldn't say necessarily expedite, but at least to put more order in court proceedings. It will be undoubtedly a long process, and this is not something, of course, that started with the pandemic. I know that the courts in Malta have been using information technology to a limited extent, yes, for the moment, for hearing of witnesses and so on and so forth. But I'm sure there's a lot of potential in which a lot of potential for the use of this technology in the future. And I think what really brought this to the fore in many respects is in fact the pandemic, I would say. So looking at it, my answer would be yes. The justice system has been impacted both negatively to a certain extent, but also positively, in the sense that I think we've been all spurred on to look at things, to begin to look at things in a different way.
Thank you, Mr. Justice. Dr. De Gabriele, if I may turn on to you. What do you believe impeded Malta from guaranteeing the continuation of an effective justice system? I mean, is it a matter of technology, preparedness, work practices? I mean, what are your views on that aspect?
Good morning. I think we need to look at this a bit in context. The courts, although they were paused. They were paused for 3 months. So let's keep that within the context of the discussion. In addition, I think that legal notice 61, or there is another legal notice that supplemented 61, also allowed for urgent cases or cases which are in the public interest still to be held with the necessary precautions. From a policy perspective, those included all those hearings which were necessary, for example, where people were held in custody and needed to have a bail hearing to see whether they should be detained in custody or otherwise. So there were hearings which were taking place. Any hearing, even in the civil courts, which was deemed and the discretion there is the discretion of the judge to hold those hearings if they were deemed to be urgent or if the public interest so dictated. So the courts weren't completely closed. They were only closed in terms of their ordinary course of business. I think we need also to keep this in context in terms of the duration of the closure of the courts to be working in the ordinary course of their business. So whilst yes, I do agree that there has been an impact, I don't think that the extent of that impact could lead to anybody arguing that there has been a denial of justice because of the short duration of that timing. But I think that there is another point which to me is very important. We were caught with unprepared this time round, and we were caught unprepared because we did not have the right processes in place. To some extent, I would consider that excusable the first time. Today, however, it is something which is foreseeable, and therefore I think that from a risk management perspective we need to prepare ourselves, because if this happens again, I do not believe it will be excusable the next time, because we know about it, it's foreseeable, and therefore we need to put ourselves in a position where we are prepared for an eventuality of the same nature. Now, is it a matter of technology? Is it a matter of working practices? It's a matter, I think it's a hybrid. It's a combination of all of these things. If we were to look at, and I mean, the Chamber of Advocates itself has taken a very close look at the matter, and not that we are promoting virtual courtrooms, again, as Judge Gaetano said, as the panacea or the be-all and end-all of this, but that it does offer an alternative, which is risk-free for in a pandemic situation, is, I think, an issue which needs to be seriously considered. There are other issues, such as, for instance, there are digitalization of the registry of the courts, which is a sine qua non, independently, in my view, of whether there is a pandemic or not. It is simply a matter of becoming more efficient in terms of the way that we do things. There are other issues which, for example, work practices in court, which in a 21st century environment are completely obsolete. We need to revisit them, and we need now to revisit them with this foreseeability of a potential happening of a pandemic again. So yes, I think we are. This is a matter now of reviewing those working practices. It will certainly need legislative amendments, because the way that our code of procedure envisages what happens in courts envisages a very simple system, which is a physical system within the precincts of a particular building. So yes, we do need to refresh these ideas, and we need to use technology to the best possible in the best possible way to enable us to still, if you look at justice as being a service to the public, we need to be able to provide a continued service to the public in terms of the justice systems independently of a pandemic. Again, I repeat, it is now foreseeable, and it will not be excusable a second time.
Thank you, Dr. De Gabriele. Dr. Grech, if I may turn on to you. I mean, Dr. De Gabriele referred to it's a mix of work practices, technology, legislative amendments. Looking at it from the Court Services Agency aspect, and the fact that, yes, we've seen development in terms of digitizing the traditional paper-based processes. However, also appreciative that a distinction has to be drawn between the civil matters, criminal matters, and possibly even at appeal stage and reviews. What is the state of play, so to say, with progressing on the back office side? Dr. De Gabriele mentioned digitization of the registry and so forth. Obviously, I'm looking at it as two separate instances. You've got the court hearing itself, which needs changes, but the back end of the operation, I think it's quite something which is within the control of I believe, the Court Services Agency. But I'd like for you to share your views on the matter.
Thank you, Dr. Pisani. Yes, initially I would like to say that during the past years, the Court Services Agency embarked on various projects which aim to provide a more effective service to the public. As we are all aware, changing the court system from almost completely paper-based system to a digitized system cannot take place on a short-term basis, but can only be implemented gradually. Of course, and I think we are all in agreement, the digitization of the court system nowadays is imperative, not only to keep pace with public expectations of justice in a modern development economy, but also to serve as a foundation for improving efficiency throughout the system. As I was saying, during the past years, the Court Services Agency has invested in an extensible management system that provides a range of electronic services. The system, that is the e-court systems, offers electronic access to case management information, and thus allowing registered and authorized users to work from outside of the confines of the court and court registry hours. In a nutshell, the system provides for 24 hours access and is accessible to all the members of the legal profession who should register themselves through the EID system. Even private persons, for instance, can subscribe to this system, but their access, of course, will be limited to view only the acts of proceedings related to their case. Another measure which was implemented is that since 2018, acts of proceedings related to civil cases are being scanned and can be accessed by the members of the judiciary and also the members of legal profession, again, through the same e-court system. Of course, there are still many acts of proceedings which have to be scanned, but there is a team of employees who are currently working on it. With regards to the online filing, although not all judicial acts can be filed online, there is a list of judicial acts which can be filed online, including the judicial letter and claims such as the small claims tribunals, European small claims tribunals, etc. The website also caters for e-forms that can be used for online filing. Currently, discussions are being held with various stakeholders to include more judicial acts which can be filed online and to amend the law accordingly. Other online services offered through the e-courts website include those of payment of fines, the payment of registry fees, applications for research for secret wills, which is very well used by notaries, insolvency register, judicial sales, judgments, etc. Ultimately, the final aim is obviously to ensure that members of the legal professions would no longer have to physically come to court. However, I must say that statistics show that the members of the legal profession are still not making use of the online filing. In fact, during the past 2 years, very, very few acts have been filed online. With regards to the online filing in relation to criminal proceedings, it is being envisaged that by the end of this year, all applications can be filed online. The system will also be available to all members of the legal profession and could also include other stakeholders such as the prosecuting officers, the probation officers, and the court experts. Moreover, I can say that as from next year, acts of criminal proceedings will start to be scanned and obviously available to the parties in terms of the law. This measure will not only facilitate the work of the lawyers, but also hopefully do away with the transmission of the acts of the proceedings from the registry court to the Office of the Attorney General. With regards to the court sittings, all sittings adjourned for the production of witnesses are being scheduled with agreement of both parties, and only those adjourned for further information are not scheduled, since the information required could be produced by a note filed in the acts of the proceedings. So, the Court Services Agency is doing its best to digitize the system in Malta, and it's doing this with a fast pace.
Thank you, Dr. Ek. I fully appreciate, and basically it's interesting to hear that we're on the track. Dr. Safraj, if hearing these experiences from obviously what the work being undertaken from the court side in terms of the admin side, as well as the practical aspects discussed by Dr. De Gabriele as well. Drawing on your experience with the Planning Review Tribunal and the boards, appreciating that it seems that from a planning perspective, it was also possible to proceed with virtual hearings. Was this possible because even from a filing perspective, architects and stakeholders involved in the process were already used to the technology platform that enabled possibly such a brisker transition, if I may dare say, to such virtual hearings, or there are other aspects which obviously you would envisage? And what were the lessons learned from that experience?
Good afternoon to everyone. So the experience at the Environment Review Tribunal, I rate it as being very positive. The fact that the procedures were already quite enabling, in the sense that all the documentation in relating to planning applications is available online, and practically the whole file is available to any person, not necessarily an applicant or an architect. It did facilitate the process. However, you need to also start with a willingness and a predisposition to effectively embrace this new method of holding sittings. We all read criticism because actually it wasn't even through a legal notice, but the main act was actually amended in the beginning of April and of March, which enabled these sittings to be held through virtual means. And we all read that there was obviously a segment of stakeholders who were critical of this new procedure, which enabled virtual sittings. Yet I would think that now with 3 months experience, the system has functioned. Yes, there are problems, cases that are being followed by a number of people, because obviously planning cases can attract some controversy, and the involvement of a number of people can be the norm rather than the exception. If you have a lot of people trying to access the system to actually participate, not just follow the proceedings, yes, there were some problems. However, I would rate that in 95% of the cases, the system is working correctly. It's not just working with the appeal procedure, but even with the cases being heard by the authority. At the moment, they're also experimenting with hybrid sittings, whereby the commission would sit within the premises, enabling even people to physically be present, but the sitting is also virtual, enabling any submissions to be made through virtual means. And I would sincerely hope that the system is retained even post-pandemic, because it is efficient. I would think that it enables every person, even those that have been very reluctant in technology, so on and so forth. Everyone has managed to participate, yet there are problems. It's not easy, for example, to examine or cross-examine a witness, and this would apply even to civil cases. However, as I said, we cannot just use a couple of problems to effectively mitigate against the system in its totality. And I would think that this experience, taking this experience now also to judicial proceedings in general, I would strongly suggest that from a judicial point of view, we start experimenting with the system, even in certain tribunals and in certain maybe court proceedings. Yet again, I do appreciate that it is not an easy solution in relation to criminal proceedings, but that doesn't mean that you cannot adopt or adapt the system to other proceedings. I see it working quite efficiently for a number of procedures before our courts of justice. It is a known fact, whoever practices in court, that not all the sittings are taken up by the examination or cross-examination of witnesses. There are a number of sittings that are held to prepare the case. There are sort of, let's call them informal pre-trial hearings as well. There are a number of sittings that are held to make some requests or request the judge or the magistrate to enable the parties to make certain submissions. Let's not forget that the procedure of preparing affidavits for witnesses is gathering pace even before the pandemic. So in any case, most of the witnesses are being prepared through affidavits. Yes, you will cross-examine the witness. And so there is a possibility of experimenting even with hybrid solutions, whereby certain sittings are held virtually, and maybe you reserve the physical sitting for specific tasks during a sitting. And I strongly suggest that the experiences that we've had resultant from this pandemic, looking at the positive side of it, we should really embrace the technology that exists to enable, not just in relation because sittings have been delayed because of the pandemic. I strongly believe that through the virtual technology that is available, sittings can be even more efficient, because experience in other tribunals who are adopting this procedure have shown it to be the case. What is important is that we start experimenting. I still think that we didn't take the full benefit of the technological means that are available in relation to judicial proceedings. I still think that there is a lot of work to be done. Obviously, the court agency is doing wonders, but I still think that there is a lot to be done. We are still pegged to a lot of formal procedures which come out of our code of procedures, and a little bit of adaptation there will solve a lot of issues. Let's not think that the registry, simply because you are presenting documentations physically, is working in a manner that is efficient, not because of the employees but the system is what it is. We've had cases even during the pandemic where you have to prepare the logistics of sending someone to the court registry to file a written document in person, and that document never reaches the chambers of the judge or of the magistrate in question. So let us not think that the physical methodology that is adopted at the registry is foolproof or is the solution. I still think that the solution is to adopt these systems of communication and these systems of filing of procedures. And I really hope that from all the negative aspects of this pandemic, we take the positive side of these solutions that are being found, and we should really embrace these solutions, because, as I said, bar a number of exceptions and bar a number of situations, I strongly believe that pandemic or non-pandemic, it should be the way forward.
Thank you, Dr. Staffraj. Mr. Justice, if I may draw on Dr. Staffraj's reference, and even Dr. De Gabriel and Dr. Rek referred to this, the procedural aspect, the Code of Organization and Civil Procedure, seems to imply, or rather explicitly indicate a preference for oral submissions and oral representations to be made. Having said that, the conversation is flowing towards a situation whereby there are certain aspects which are more practical to be filed in paper format or written format, and indeed there seems to be also a preference by practitioners, lawyers, and to a certain extent even judges, to get written submissions in court and affidavits and so forth. Drawing on your experience in Europe, where, especially Strasbourg, where the process is quite paper-driven, or rather written submissions-driven, is that the possibly right approach for Malta to take, to shift more towards the written process, or possibly sticking to the more oral verbal submissions, possibly more akin to the British system, would be a preference? I mean, drawing on your mixed experience now, being on both sides of the courtroom, if I may.
Thank you, Dr. Pisani. Well, let me make it quite clear, first of all, that the dichotomy written-oral does not necessarily bear any direct relationship to the dichotomy virtual or real. So we're talking on two separate levels, okay? Oral and written. You're quite right. The proceedings in the European Court of Human Rights are all in writing, with very, very rare exceptions that we hear oral submissions, and even rarer exceptions that we hear witnesses. Having said that, of course, you must bear in mind that, ironically, the provision of Article 6 of the European Convention on Human Rights does not apply to the European Court of Article 6 of the European Convention on Human Rights does not apply to the European Court of Human Rights. So, for instance, the necessary requirement for publicity, which is a necessary requirement of Article 6, as it is of the corresponding provision of the Constitution dealing with due process with fair trial, does not apply to the Strasbourg Court. Let me now, so that is the issue between virtual and real. Oral or written? Yes, our code of organization and civil procedure and the criminal code lay a lot of emphasis on the oral pleadings. And this is, in a sense, an offshoot of the requirement also of publicity. Why? Because in the oral submissions and the oral proceedings, you also get the opportunity to examine and cross-examine witnesses, things which have already been referred to, I think, by Dr. Grech, even Dr. Gabriele and Dr. Stavraj. Although our codes still emphasize the oral aspect of proceedings, in practice, as you have rightly said, there is a tendency of, especially in civil proceedings and commercial proceedings more than in criminal proceedings, for lawyers to resort to written submissions. Now, this could be useful provided that those submissions are relevant and that they do not necessarily burden the record of the proceedings with unnecessary documentation. My experience, not from Strasbourg, but from the courts in Malta, when I was both a judge and Chief Justice, is that unfortunately, many lawyers nowadays prefer to file written submissions, which is not a problem. But unfortunately, these written submissions then tend to be never ending, with the result that you may get the record of proceedings, which will be calculated not in volumes or weight, but in how thick the record is in inches and feet, probably, if not also in yards. Okay. Provided that the written proceedings are focused and they can be controlled by the judge or magistrate concerned, yes, written proceedings could assist in facilitating, in expediting proceedings. This would apply mostly in civil and commercial cases. You mentioned the United Kingdom, or rather England. Well, in England, and I suppose also in Scotland and Wales, they have the system, for instance, of skeleton arguments, submitting skeleton arguments before the actual trial. The pre-trial proceedings are handled by usually the registrar, by registry officials, and then the date, let's say, for the hearing in the High Court in England, let's say, would be limited to not so much hearing witnesses, because even affidavits there are used, but actually listening to oral submissions on the very specific point, legal point in issue. As soon as those submissions are over, generally the court immediately proceeds to delivering an extempore judgment. That is one way forward. Now, all this, of course, is not necessarily related to the other dichotomy, virtual or real, because there you have a totally different circumstances which come into play. The written proceedings, of course, have less value in criminal proceedings. Let's take trials by jury. It's virtually inconceivable that submissions in a trial by jury can be made, in writing. Why? Because a trial by jury is essentially the appreciation of the evidence, but by the jurors, 9 men of average intelligence, or as some would say, of average ignorance, whichever side of the coin you want to look at it. But there you have these 9 men who have to understand what actually happened in a particular case. That cannot be done, in my view, either by oral submissions nor in a virtual setting. It has to be done in a real setting. But there are other instances, other jurisdictions, like in the Court of Appeal, when everything has been virtually already trashed out at one level of jurisdiction. Remember, in Malta, we do not have 3 levels of jurisdiction. We only have 2 levels of jurisdiction, first instance and appeal. So everything has been trashed out in the first level of jurisdiction. Why is it necessary to have oral submissions again, except in exceptional circumstances? Let's say something new is discovered at the appeal stage. And then at that stage, at the level of Court of Appeal, it is quite conceivable that everything could be done in writing, and also that where necessary, the proceedings, probably even just pre-trial proceedings, could be conducted virtually. And if the parties and their lawyers don't have anything further to submit, the parties will inform the court that they can rely on the written documentation, and the Court of Appeal will simply proceed to judgment. I was told recently that this experiment has been taken up by one of the sections or divisions, I don't know if it's called section or division right now, of the Court of Appeal, and it seems to work well. So again, the issue basically boils down to that you cannot have something that fits all. You have to adapt and adopt, as Dr. Stafrace quite rightly said, your tools to the appropriate jurisdiction that you're dealing with. If you're dealing with a tribunal, a small claims tribunal, you cannot proceed in the same way as if you're dealing with a Court of Appeal. If you're dealing with a district court sitting, a magistrate's court sitting, it's not the same as when you're dealing with the Constitutional Court, for instance. Thank you.
Thank you, Mr. Justice. Dr. Gabriele, drawing on Judges De Gaetano reference to the pilot project on the Appeals Forum, but also looking at the active contribution the Chamber is making towards both putting up a case for virtual hearings and the paper published and providing numerous alternatives. How do you contextualize the current state of play following the relaxation of the expectations in terms of court hearings and so forth, and the way forward should basically, as you alluded to earlier, we need to be prepared if further restrictions come into play in a few months' time or in the near future?
I think that I'll take this up on the basis of the need to adapt, but also that there cannot be a one-size-fits-all. So first of all, the case we have made for virtual hearings was a case which was made in the context of a pandemic and how we could guarantee the continuity of the court working in that particular context. And we found that virtual hearings could offer us a zero risk alternative. However, I would like to take part of Judge De Gaetano's position on the difference between written and oral as opposed to virtual versus real. And I think that both have a contribution to make to render our justice system more efficient. And I'll take 2 examples. The first example is where we can really use written pleadings to their utmost effect. And I am aware, because the Chamber has been consulted, on rendering appeal proceedings fully written proceedings without the necessity of oral hearings. Let me just tell you what difference that makes to the current situation. Today, if you file an appeal, it takes around 4 years to get a first hearing on appeal, and what you do during that first hearing is make sure that all the administrative issues have been tackled. So security for costs has been paid, all parties have been notified, and the court, together with the lawyers, will agree on a second hearing when that appeal will actually be heard, so that the parties will be able to make their submissions to the Court of Appeal on the basis. Now, that's going to take, so in all, you will probably get a proper hearing, or the actual hearing of appeal, within 4.5 years. What is being proposed is that you file an appeal, you will be given a longer time period to file an appeal, so that what today is 20 days from the date of judgment at first instance. I'm speaking here of the civil appeals, not criminal appeals. You will be given 40 days to file that appeal, but you have to now make sure that your application is as comprehensive and as exhaustive as possible. The other side will get another 40 days to reply. And once that is done, you have 3 months to pay security for costs, and the whole record will go for judgment. So at the end of the day, the Court of Appeal will have in front of it the full record of what happened at first instance, the appeal application, and the response of the appeal, which is more than sufficient for the court to be able to proceed to judgment. There will be, this will not apply to constitutional cases. Constitutional cases will be heard, and there will remain the oral submissions in constitutional cases, constitutional appeals. The idea here is that what previously would have taken 4 years to get to a hearing, now within 12 months, it is possible to actually proceed to judgment in an appeal case, simply by removing the requirement of having a hearing, except where the court itself, on the basis of written pleadings, is not satisfied that it has sufficient information to be able to proceed to judgment. So over here, this is just an example of how simply by changing, and there's nothing virtual about it so far, simply by changing a system which is based on oral submissions as if it's the be-all and end-all into written pleadings can actually render the system much more efficient. During the COVID-19 period, we actually did run a pilot project with the Court of Appeal, the third section of the Court of Appeal, where 10 cases were chosen by the Court of Appeal. And with the collaboration of the Chamber, we actually contacted all the lawyers to try and see whether they would be amenable to have virtual hearings. And from that pilot project, they actually happened. And from that pilot project, it seemed that even judges who are currently in the Court of Appeal, possibly the first case was difficult. The second one was also difficult. But by the fifth and the sixth case, they also became very familiar with the platforms they were using, with the way they could manage people who are not in court physically in front of them. And it was a huge success in terms of the way it was handled. We also have to appreciate that during an appeals hearing, it is simply the lawyers who are making submissions. So you don't have evidence being given in front of the court. You don't have case management issues to deal with. So it is the easier part to hold virtually. Moving on to another issue, and I'll now look at first instance proceedings. I think that a lot of those proceedings, or rather the actual sittings, can be avoided. And I refer here to a number of sittings that normally take place, which are merely case management sittings. For people who are not used to court, you will find, if ever you went to court, that you will have halls that have, for example, 10 cases all appointed to be heard at 9 o'clock. Now, we're all humans. We all know that you can't quite be doing 10 different things at the same time. Most of those cases will not be cases where evidence is being or witnesses are being heard, where lawyers are making submissions or substantive submissions about the case, but most of them are case management. Where are we in this case? It takes 5 minutes for the parties to address the court, giving further information to the court. whether you need new witnesses to come to the fore. A lot of that case management can take place without a physical sitting in real terms. You don't even need the judge to be conducting those sittings. You can have people within an administrative capacity that can handle those, and allow therefore the court and the judge to focus on those sittings where you really need the judge to be focused, and allow the lawyers to be dealing with the submissions they need to make, which are really substantive. So I think there's no 100% answer to the question. It has to be a hybrid system, because there are different issues that arise in different courts, in courts of different jurisdiction, in different cases, which some cases are simple, others are much more complex. So I think we need to be aware of what the tools are and how best we can apply those tools to the different courts, to different kinds of cases, but being open to new ideas that yes, we should be able to hold even virtual hearings. Funnily enough, in our Code of Organization and Civil Procedure, the only provision which deals with a virtual hearing is the most difficult part of any hearing, which is the examination and cross-examination of witnesses. So, for example, we do have provision in our Code of Procedure where if a witness is not able to be in court, a judge can order that he wants to hear that witness, whether in examination in chief or cross-examination, remotely through video conferencing. Now, that creates a number of issues. For example, we make sure in a court of law that a witness is not present unless he is giving evidence during a discussion of the case, because he should not be influenced by any third parties as to what he is saying when he is giving his own testimony. So there are issues with video conferencing in this respect. For example, is the witness on his own in the room? Is he being influenced by anybody who could be prompting him to say certain things? So these are all issues that we need to iron out. But again, funnily enough, and then it's uncanny that our Code of Procedure actually allows the examination and cross-examination of witnesses remotely and through virtual hearings. We now need. In my view, there are other aspects, for example, oral submissions by lawyers at the end of a case, which can easily be done on remotely and through virtual sittings. I find that the taking of evidence is the more difficult part, but nonetheless, our Code of Procedure already provides for that, but for nothing else.
Thank you, Dr. Gabriele. Dr. Safrace, drawing on the real virtual conundrum, if I may put it, of the hearings, and my understanding that you do have a bit of a reservation for the recommendation that parties wouldn't be present during the sitting. Would this hybrid approach appease your concerns there? And if I may push the question further, we're talking about digitization and hybrid methods. Where would you deem it appropriate to draw the line between the shift towards digitized processes as opposed to retaining the brick and mortar approach?
I am not one of those lawyers who claims that, for example, the lawyer should not receive notifications on behalf of clients, so on and so forth. The way the system is working at the moment, most of the communication is made via the lawyer. The lawyer would receive the decrees, the lawyer would receive communications by the judges' chambers, so on and so forth. And I think that is the way forward. After all, we're here to offer a service to our clients, and we should be equipped enough and responsible enough to also take on the role of even assisting the client in this process. Let's keep in mind that some clients would have one court case in their lifetime. So saying that we shouldn't be accepting notifications, we shouldn't be receiving information in relation to the client, I don't have any issue with that. However, I have a very strong reservation when we start being told, listen, if if it's not necessary for the parties to attend to the sitting, please inform them not to attend. The case remains and belongs to the client, not to the lawyer. And I can't accept that the party is told, listen, if you don't need to be present because you're not going to testify, you need not attend the sitting. Through virtual technology, I've had experience in other fora where you make the sitting available to anyone. We've had journalists reporting specific cases simply because they had the facility from their office to follow a particular case or a particular sitting. And yes, in today's day and age, if the party doesn't need to physically attend, we've had also, let's look at the bright side of it, we have clients who reside abroad. I've done cases virtually. I'm here at my office, the tribunal is being held and they are in their offices at Floriana, my client being a foreigner following the sitting as if he is present here from some other part of the world. So let's not underestimate these benefits of having the virtual means available to everyone, because the way even Malta is developing, the way Malta has developed, we're not just a restricted group of people who reside here permanently. I mean, the way Malta has developed, we've got clients from all over the world, not us as a firm necessarily, but even in general. So these individuals need to have adequate access to an adequate justice system, and I think this even facilitates it further. So yes, I see that as being the way forward. To take a clue from what Louis suggested in relation to the proposals being made to cut the time frame of appeals, obviously there is a debate on that. I don't think that is the only solution to the problem. It's true, it's unacceptable that in today's day and age you need to wait 4 years for your appeal to be heard. There may be other solutions as well. Let's not underestimate the fact that the judges who will be presiding the courts of appeal will, in most of the time, literally be secluded in their own offices writing judgments, rather than spreading their time between writing judgments and holding sittings with oral pleadings, so on and so forth. As I said, I have my reservations on that system. It's true we have a problem, but I don't think that this is the only solution to the problem. So let's look at things even in a wider context. I do believe that in an appeal procedure, the written submissions are the most important submissions that you make, because obviously the courts of appeal wouldn't in normal circumstances be hearing witnesses, but let's not also forget that a civil case may take years to be heard and decided. For the party losing that case, an appeal is the only hope of a remedy. So let's not just look at appeals by number or by dates within which they are decided, because for the people who are accessing the courts of appeal, the appeal is the only final and definitive remedy in relation to a matter that they have in dispute. If I had just to summarize, because I'm sure that we're running out of time, and maybe some suggestions that may be obviously put to the table for further debate rather than for a decision. Most of the participants also mentioned it. Today we have the benefit, not that in the past it was different, but most of the chambers are very well equipped. Most of the staff of the judiciary is composed of people who nowadays know the procedure and know the rules and the substantive part of the laws in a lot of detail. I think that a lot of engagement can be made even with the staff of the judiciary through electronic means, through normal submissions. I mean, we communicate amongst us lawyers through very simple methods, through emails, so on and so forth. We exchange agreements which run into millions in value by emails. I can't understand why we can't communicate, or whether that should be the rule in relation to communication even with not the judiciary per se, but with the members of the staff of the judiciary. We need to be more enterprising in relation to pre-trial procedures in relation to civil cases. My experiences in civil cases and commercial cases. As I said, most of the sittings are not taken up by the summoning of witnesses, so let's work to hold sittings in a more productive manner. As I said, we don't need to try a system which applies to each and every court all at once, but we can start with soft procedures, and the experiment that the chamber piloted in relation to the inferior appeals, I think, is a way forward even to determine how we should proceed. As a rule, as I said, I tend to look at the positive side of even a problematic situation that we are encountering. Very little did we estimate how positive the outcome can be when we are faced with such a problematic situation. I think this pandemic has really brought us to accept that certain things have to change and need to change. And as I said, if we develop and we continue building on this experience, I would think that the system will improve dramatically. God forbid, we're past the pandemic. It's good that we're past and we'll get past the pandemic from a health point of view. But God forbid we get over the pandemic and we don't build on the positive shoots that we have experienced over these last couple of months, both in relation to judicial proceedings, both in relation to other entities where virtual and online submissions have become the rule rather than the exception. And today, let us not also underestimate the willingness that there is outside for the normal citizen who accesses the justice system, the willingness that these people have to adapt to these new methods of communication. Let's not use any excuse whereby we maintain that people don't have access to these virtual means of communication. Everyone is obtaining all experiences, and everyone has the capacity to participate. Let's address that segment of society that may not have this full accessibility, either through means or through knowledge. Let's not disregard that aspect as well. Let's make the technology available to everyone. And I'm pretty sure that if that is made available, a system that is improving should continue improving, in my judgment, dramatically.
Thanks, Ian. Dr. Grech, looking at the work that the Court Service Agency is carrying out and noting that there's quite some work going on with the European Commission for the Efficiency of Justice in terms of the use of technology in the system. Would you be able to give us a bit of an update as to what we're likely to see in the coming months or years on that aspect and where we're heading to?
Yes, there was a project that you are referring to that was split into phases. Phase 1 has been concluded and followed a series of international and national recommendations for the improving and functioning of the Maltese judicial system. I can say that some of the areas for improvement included the criminal and civil judicial procedures, the issue of the extensive length of the judicial procedures, and the organization of the system of court administration. This project was funded by the Structural Reform Support Services of the European Commission, and it was aimed to strengthen the efficiency in the Maltese system. Now we are commencing phase 2, and in fact in May of this year, the Ministry of Justice has launched the second phase of the project funded by the Social Reform Support Program, entitled Establishing a Digital Strategy for the Maltese Justice System. Throughout the coming year, experts from the CEPEJ within the Council of Europe will be working with the key justice stakeholders in Malta in order to attain the following objectives. And they should carry out analysis of the current IC initiatives within the justice sector. They will assess the application of digital strategies abroad. They will carry out horizontal discussions with all stakeholders in the justice, and subsequently will delineate the parameters of the justice strategy. And finally, they will then draft a comprehensive digital strategy and accompanying action plans. And we are very looking forward to this.
Excellent. Thanks, Vanessa. In conclusion, I mean, my reading of the points raised is that a hybrid solution seems to be the preferred way forward, and it's not just a matter of technology. Looking at the short, medium, and long-term aspect, and if I may ask for a comment from each one of the panelists, what would you prioritize for the short, medium, and long term as the key aspect to be addressed in the interest of an effective justice system, bearing in mind the risk of a second wave of the pandemic? Possibly, may I ask Mr. Justice De Gaetano to start off, and then moving on.
Very briefly, and irrespective of whether there is or there is not a pandemic, I think that there are two issues which Dr. De Gabriele has highlighted, and I think others as well, which I think need to be addressed possibly immediately. And they have not necessarily a direct relationship with the question of whether it's virtual or real. One is the issue of case management, particularly in civil proceedings, civil and commercial proceedings. Yes, I think there is a lot of room. We've been talking about case management for the last 25, 30 years. The system of the master was introduced originally for the purpose of case management. It failed. Then we had judicial assistants who were authorized, who were given the power to hold pre-trial hearings. Again, because many of them were not up to standard, the whole system failed. Case management, whether virtual or real, is, I think, the core issue that Dr. De Gabriele has quite rightly pointed out in civil and commercial issues for a more efficient system of courts in civil matters. The other issue, and this applies to both civil and criminal matters, is it's true, you can go to appeal and then ultimately, even in a criminal appeal, ultimately rely on written submissions. However, it is also important, I think, that the judgments of the courts of first instance, be they be the magistrates' courts, the court of the first hall of the civil court, or whatever, the judgments should be more focused, intelligible, and not rambling with the apparently, I'm sorry to have to say this, but some members of the judiciary nowadays think that the value of a judgment is to be assessed in the number of pages that have been produced at the end of the day. This is sheer nonsense. And I keep constantly, perhaps it's my bad luck that I choose to read these judgments, I pick on one and they always happen to be the same. That you read a judgment, whether it's a magistrate's court's judgment or a judgment of the first hall of the civil court, which you have reams and reams of unnecessary information. Instead of focusing on the facts, the legal issue, and then the decision, you have a repetition of all sorts of things. Now, that is not conducive to efficient management of a particular case, whether it is civil or criminal. And that is something that only members of the judiciary must attend to. There are, of course, some members of the judiciary who are very good at this. They simply focus on the facts, make a summary of the facts, even in criminal proceedings. Note what the law is and apply immediately the law to the given facts, or rather to the facts as to the resulting facts. But in the majority of cases, we've got rambling judgments, and that has to stop. Thank you.
Unfortunately, I'm still a practicing lawyer, so I can't be as scathing as Judge De Gaetano has been about judgments. But I will highlight just 2 points. In my view, I think that there are 2 issues we really need to look at. The first is quite broad. It's reviewing our working practices, I think. And here I would include not just technology. Technology is not the be-all and end-all. I think we need to make use of technology but it is not the end in itself. It's simply a means to providing us with a better justice system, a more efficient justice system. But included in working practices, I think we need to look and be autocritical about this and do some process re-engineering. So our procedures, which have been there, which are long-standing, some of which are obsolete, I think we really need to look at them again and devise working practices that work today. In this, I think that even we as a profession need to really look at the way we're organized, at the way we handle things, and possibly even change the way we are organized, the way we actually work, with not only within the courts, but also outside. The second point, which I would like to mention, is quality. And I think this is important. I don't believe it's something that we need just in the justice system, but across the board. I think we are becoming slaves of numbers, to the extent that if something can be quantified, then it exists because there's a number we can attach to it. So, for example, it is not what the quality of our judgments are that are delivered by our courts, which is tested, but the number of judgments that a judge delivers. And what does that entail? That entails that if the quality of those judgments is not good enough, you're going to have a bottleneck in the Court of Appeal, because people are going to appeal those judgments. So we really need to look at the system and improve the level of quality. It is unfortunate that quality cannot be attributed a number, but it doesn't mean that quality does not exist. Of course it exists. And I think that one of the first things we need to do is really elevate the level of quality across the board in everything we do. We will not be able to give it a number, but we will reap the benefits of good quality.
Thank you, Lewis. Possibly Vanessa.
Yes, thank you, Wayne. During the pandemic, the easiest solution for the continuance of court sittings during the closure of the courts would have been the creation of virtual courtrooms. However, as Dr. Gabriele already said, the law seems to allow the use of video conferencing only in the case of collection of evidence. In fact, in the absence of such legislation and in agreement with all the parties, 6 sittings in the Court of Appeal have been held and live streamed, which proved to be successful. Applications that needed to be dealt with urgency, such as warrants of prohibitory injunction and family court applications, they were all heard through the team system, and certain mediations also have been held remotely. In the meantime, discussions are ongoing in relation to legal amendments that we need to have in place. Also, as an agency, we embarked on a pilot project to allow sittings remotely from 2 different halls. The judiciary also can make use of the video conferencing, and the agency will make sure that all necessary resources are available for the possibility of virtual sittings. Ultimately, our aim is to continue working to provide a framework where justice is delivered efficiently and in a timely manner.
Thank you. And finally, Ian, Dr. Stafrach.
I mean, I think Lewis was really very specific in certain comments that he made in relation to the way forward. Yes, all of this boils down to not just technology, because you can have all the technological means at your availability, all the solutions ready available. It also boils down on quality and also on the willingness to adapt to certain new realities. I believe that the vast majority of the stakeholders in the justice system, be it the lawyers, be it the judiciary, be it the legal procurators, the vast majority of all stakeholders is willing to collaborate, is willing to go that extra step to enhance the output. As the Honourable Mr. Justice said, case management remains a critical factor in all of this. A lot of experiments have been held over the last years, and let's say some were partly successful, but the majority seemed to have yielded no benefit or no result. I don't think it is always the fault of the administration or of the people who are proposing these solutions. I think us lawyers, we need to be in a position to adapt more to new realities, because we can't simply keep complaining that our Code of Civil Procedure is littered with a number of archaic provisions, and then we are the first to resist particular changes. I strongly believe that this experience has shown that out of necessity, we have to adapt to new solutions. The necessity was very obvious. The solutions are quite obvious. One last point, again, Lewis mentioned it. Let's not just look at numbers. I am very much allergic to people who quote and who rate the justice system by numbers. The justice system is complicated in its core, and it is very disrespectful, not towards us lawyers, because we are one of the stakeholders, but it is very disrespectful towards our own clients, towards the people who need an access to justice to obtain what is rightfully theirs. I assure you that those people who, as I said, may have only one case in court throughout their lifetime, they're not only offended by hearing their case being referred to as a number, but they feel that the justice system is failing them when we start referring to their case as being just a number. So let's look forward and let's reap the benefits of the necessity that has been created through the pandemic, and continue building on successful stories that we've been experiencing, with a view of rendering justice more available to whoever is seeking it, because ultimately justice is there to serve the citizens of this country and not vice versa.
Thank you, Ian, and thank you, Mr. Justice De Gaetano, Dr. De Gabriele, Dr. Grech, and Dr. Staffrach for these insights. I thank also the audience for following us today. And on this basis, I conclude this webinar and hope that there will be more to come and that the debate will be continuing. Good afternoon to all.